Hi, we are Amy Oppenheimer and
Tina Ro-Connolly.
And our law office does workplace investigations. As attorneys, what we do is investigate complaints about harassment or discrimination or misconduct. And our presentation is about how to do investigations, or how, if you're going to hire somebody who's going to do an investigation because you're in-house counsel, or you are outside counsel for an organization doing employment law, or if you're a plaintiff's attorney and you're representing somebody who feels they were mistreated at work and they should have had an investigation, or there was one that didn't go so well. We're going to talk about what factors to look at to make an investigation appropriate and compliant with the law. And what we look at to analyze that are guidelines that are set forth by the Department of Fair Employment and Housing, the EEOC, Professional Organization for Workplace Investigators, the Association for Workplace Investigators, and primarily we're focusing on what these guidelines tell us about appropriate practices for performing investigations. And there are a number of factors that we want to highlight that are important for investigations. And the first one, I think, is just the fairness, due process, right, Tina?
Yes, due process. It is a term that's incredibly variable. Due process means something different in the civil arena, it means something different in the criminal arena, and it also means something different in context of workplace investigations. And what the DFEH guidelines tell us about due process is we are trying to implement this notion of essential fairness. And what essential fairness means is speaking to the complainant and getting the full picture of what it is that they're concerned about, and also giving the respondent an opportunity to respond to those allegations.
And as workplace investigators, we're coming in and part of providing that due process. Fundamental to what we do is impartiality.
Yes.
You want to talk about that too?
Yes, impartiality. I think that's something that the DFEH guidelines, the EEOC guidelines, and the Association of Workplace Investigator guiding principles are all consistent on. Impartiality is so critical to investigation. So everybody is consistent about saying investigators must be impartial. And part of that, even though we as investigators have training about checking our biases at the door and making sure that our personal biases don't affect our analysis in an investigation, what's so critical about impartiality as well is the perception of bias, the optics of an investigation, and making sure that the investigator doesn't have any perceived biases, like a personal friendship with somebody who's involved in the investigation, or a long-standing, cordial, friendly working relationship with someone in the investigation. So it's not only is it important to address actual impartiality, it's also important to address perceived impartiality as well.
And so investigators like us need to be trained. A lot of investigators are internal to organizations. The DFEH guidelines talk about the need for training. Those of you who are new to the field, there's great training available through the Association for Workplace Investigators, and some of us even have a certificate in doing investigations called the AWI certificate holder, which comes from going through a institute training and then taking a test and passing that test. Other ways you can become qualified, or is just your experience. There are other training programs and resources out there. I'm going to skip to a couple of other things that are important, I think. Sure. One of the things investigators do is make credibility determinations, and so it's really crucial that you understand the basis for making a credibility determination, that in the evidence code there are the lists of factors that you can use, and DFEH guidelines include those credibility factors and talk about the fact that investigators should be making these determinations. When you do an investigation, you're making a decision as to whether certain facts occurred or didn't. You're making a factual finding, and it's based on a preponderance of the evidence. So, of course, we have different legal standards, beyond a reasonable doubt, the criminal standard, clear and convincing for some limited types of cases, but in civil cases, So in a discrimination case, it would be a preponderance of the evidence. When you investigate something, you should expect that either you as the investigator or the person who you hire, the internal person, should be using that preponderance of the evidence standard. We talk about that as 50% plus a feather. And that the reason that's also tied to credibility is you may have to make a he said, she said, or a he said type credibility determination. The fact that you don't have an independent witness doesn't mean that you're not going to make a finding. You're going to have to evaluate the information that's provided from that individual and see if you believe it's more credible than the other individual or not.
Right, and I think a couple of things about credibility and why it's so important is in the he said, she said types of cases, we are in our training, we are trained to make a finding. In other words, we don't just throw up our hands and say inconclusive. We have to make a finding, and we are trained to make a finding, and the way that we're able to do that in the he said, she said type cases is through credibility analysis. And I think the second thing, and we delve much more into this in our presentation, but I think important to point out here is that credibility is something that's much different than demeanor. And what we are not looking at is the demeanor of the people that we interview. In fact, studies show that that's not particularly effective when determining credibility. We look for other factors.
And you know, one of the things I want to just sort of plant the idea in here for new lawyers especially is that this is a whole field of law that now many people, rather than litigate, if they're in the employment area and they're interested in this, they do these impartial investigations because in order to deliver on impartiality, a lot of employers are in a position where they have to hire an external attorney to do it because the person the complaint's against is the CEO or the head of human resources, or they just don't have the internal resources to do it. And it's really a fun, interesting area of law where you can use your legal skills and be an impartial.
Right. I enjoy it because you get to be a fly on the wall and to sort of experience these different workplaces and to sort of hear the inside story of everything going on, and you have the opportunity to sort of to make your determinations and share with the employer what you think the concerns are, but ultimately the obligation is not on you to fix it. So that's, I think, what makes it such a fun area. It's constantly changing. You're introduced to new work settings all the time, and there's always such a variety of cases that we handle.
And a lot of large organizations hire internal attorneys to do these, and then there's like little boutique law firms like us. We've got about 10 attorneys just doing workplace investigations.
Yes. And trainings.
And training, and training people how to do them.
Yes.
And again, circling back to the kind of skills you need, you're going to be making these determinations, weighing the evidence, and then there's a lot of writing because you've got to be able to explain your findings and write them out. Another key factor that we talked about is documentation. You have to document what you've done. So either through a tape recording or taking notes, you have to have consistent documentation that you hold on to. And then your report that analyzes what those findings are and uses the burden of proof and the credibility factors to bring it all together. One of the things we talked about was not reaching a legal conclusion in that finding. Do you want to talk about that?
Right. Oftentimes as workplace investigators, we explain and we make clear to our clients and to everybody who's involved in the investigation, our role is not to make a legal finding. Our role is to make factual findings. So by a preponderance of the evidence, did this occur, yes or no? And then once we as investigators have conducted the investigation, looked at relevant documents, spoken to all the key witnesses, weighed credibility, and we make our findings and we share those factual findings with our employer clients, and they take our factual findings and they consult with their what I call their real attorneys to make the legal conclusion. So what we provide is a tool and a roadmap to assist the client and their counsel in making determinations of whether or not harassment or discrimination or general workplace misconduct has occurred.
But I have to remind Tina, we are real attorneys.
We are real attorneys.
Too. Doing investigations is hard work. There's the analysis that goes into it, and the skills that it uses as a lawyer can be very demanding and also very rewarding. And
Yes.
the point is that you're getting a product to an employer that hopefully can give them a roadmap for what the problem is, what the genesis, help them figure out solutions, really with the goal of figuring out the truth and making the workplace a better place.
Right. So hopefully that gives you a good introduction of what it is that we do as workplace investigators, and we've enjoyed speaking with you.
Thank you.